Good afternoon. Welcome. Thank you for joining us for our presentation today. We are going to be talking about employee speech in and out of the workplace. My name is Mike Harrington, and I'm chair of our Labor and Employment Practice Group here at Murtha Cullina. I'm going to take a moment just to go over a few housekeeping matters. All callers are going to be currently in listen-only mode, and you'll remain in that mode during the presentation. If you have any questions that you would like answered at the end of the presentation, please write them in the questions box in your webinar toolbar, and as I mentioned, we'll answer those at the end of the presentation. All of today's participants will receive an email from Jackie Rowe after the webinar with a link to our PowerPoint presentation. Feel free to share that with others in your organization, and an attendance certificate for those who are seeking continuing education credit will be sent. Okay, so why don't we begin? So we're certainly talking about something that is extremely timely. The issue is fundamentally this. An employee of yours expresses some opinion that's either offensive or controversial in some way, an opinion that does not align with the company's mission or principles, or an opinion that is critical of the employee and its employees. So basically, someone is saying something that is not upsetting, upsetting and not appreciated by the employer. So we certainly see this happening in the news today. It seems like this is an issue that is not going to be going away anytime soon. The NFL players who are expressing themselves by kneeling during the national anthem. That is not actually something new. In preparation for this presentation, and some of you may recall this, but back in the 1960s, David Megacy played for the St. Louis Cardinals. He was an anti-Vietnam War advocate. He refused to salute the flag and bowed his head during the playing of the national anthem. Interestingly, rather than having the support of the crowd for his protest, he was jeered. On a similar note, we have Jemele Hill, who works for ESPN. She's made a couple controversial tweets in recent time. First, she referred to President Trump as a white supremacist. She had a conversation, from what is reported, with management at ESPN, and then shortly thereafter called upon fans to take indirect action against the Dallas Cowboys after the owner told the players that they would be benched if they did not stand for the national anthem. Specifically, what she was calling upon are fans to boycott products of advertisers who advertised during that game. Following that, she was suspended for 2 weeks for violating the company's social media policy. As of today, I'm not aware of her taking any legal action to challenge that, but we'll have to see. And then not too long ago, Curt Schilling, another ESPN employee, he got himself discharged after posting a Facebook post regarding the bathroom bill in North Carolina, where many people found the post to be hostile to transgender individuals. So a very timely situation. I know in my practice, I've gotten several inquiries of late regarding various posts or other social media commentary made by employees that employers have been upset on. And the fundamental question is, what can I do? So as we begin to think about that question, I think it's important to understand the various legal issues that can present themselves in such a fact pattern. First, you have federal law. Both the First Amendment of the Constitution might come into play, depending on whether the employer is a public employer or not. The National Labor Relations Act, and we're going to look at that. And then we're going to look at a variety of statutes protect certain activity, and that could be caught up in one of these fact patterns. Here in Connecticut, we have a very specific statute on point, Connecticut General Statute 31-51Q, which extends protection for an employee's speech in the private workplace. And we're going to look at that statute closely. And also, we have state statutes that protect individuals from engaging in certain protected activity. There might also be local law in your jurisdiction, as well as collective bargaining agreements may present certain protection for employees, as well as potentially individual employment agreements. So let's begin with the Constitution. A lot of folks will, sort of in a reactive situation, say that, well, I'm simply exercising my First Amendment rights. Well, the First Amendment rights is a restriction on government. First and foremost, the federal government, and that restriction on the government in terms of quelling an individual's speech has been extended to states through the 14th Amendment. But if you are, and I know some people listening today are public employers or quasi-public employers, the Constitution, the federal Constitution, and potentially the state Constitution, which we're going to explore a little more detail later, does create a restriction on disciplinary action based on someone's speech. In terms of protected activity, there are a number of statutes that could be the source of protection. For example, Title VII. Title VII not only prohibits employers from discriminating against individuals because of certain protected classes such as race and gender, but it also protects activities where someone opposes what they consider to be, in good faith, a discriminatory practice. So when someone speaks up opposing such a practice, they are engaging in protected activity. And if an employer was to take disciplinary action based on that speech, they could be running afoul of those statutes. And similarly, under the Americans with Disabilities Act or the Age Discrimination Act, if people were protesting activities that they felt were discriminatory against a disabled individual or an individual because of their age, they would similarly be protected. And in a similar nature, Title VII, or Section 7 of the National Labor Relations Act protects employees when they engage in concerted activity. That means activity that is either involving or on behalf of two or more employees for their mutual aid and protection with regard to the terms and conditions of employment. So when someone, and there have been many, many cases where individuals have engaged in what the NLRB, the National Labor Relations Board, has found to be protected by Section 7, where in social media posts, the employees have been critical of the employer, either because of their compensation levels or the types of benefits they offer or the terms and conditions that the employee has to work under. They've been critical of the employer in that regard, and they've expressed that criticism publicly through social media or through other public means, and employers have been not pleased with that and have taken disciplinary action. And that has resulted in the employer typically getting a charge and then a complaint from the National Labor Relations Board. One recent case that I think really highlights this is a case that went to the Second Circuit Court of Appeals. And this is the Court of Appeals that hears cases from New York, Connecticut, and Vermont. This case involved a situation where there was an active union campaign. The individual, Mr. Perez, worked as a server for the company Pier 66, which was a caterer. During some interaction during the period where the union campaign was ongoing, a supervisor spoke to Mr. Perez in a way that he found to be unduly harsh. And the supervisor spoke not only to him, but a couple other employees. In reaction to that incident, Mr. Perez wrote on Facebook that Bob is a nasty mother, who doesn't know how to talk to people, expletive his mother and his entire expletive family, what a loser, vote yes for the union. Needless to say, the employer was not happy when that post came to its attention, and it terminated Mr. Perez's employment. And as the case noted, the actual post did not have asterisks. It had the full profanity. So what happened was Mr. Perez went to the National Labor Relations Board, filed a charge. The board investigated and issued a complaint. After the complaint was issued, an administrative trial was held, and the administrative law judge found that the commentary, even though it was colorful, was nevertheless protected. And because he was fired for engaging in that protected activity, a violation was found, and the company was ordered to reinstate Mr. Perez and to make him whole. The company then took an appeal to the Second Circuit Court of Appeals, challenging the order of the NLRB. And the Court of Appeals decision is interesting. They certainly were not happy with the language. They felt that this reflected the outer limits of what probably would be considered protected activity, but they upheld the board's decision. And they did so for a couple different reasons. First, the post concerned workplace concerns. It talked about treatment of workers and about an upcoming union election. So clearly those related to workplace issues. The other, one of the second reasons that the court cited for affirming the board was that profanity had been tolerated in the workplace. And I think this is maybe a significant issue for employers to think about in terms of, if you're going to call an employee out on certain conduct, you want to make sure that this is not the first time someone's being called out, that you have taken steps to create a culture where if an employee acts out in this way, it is inconsistent with the established culture. But here, there was, I guess, sufficient evidence to show that profanity was tolerated and never resulted in discipline before. And third, the court went on to note that the comments were not made in the presence of customers and did not disrupt the catering service offered by the company. I think this is important because when we begin to reflect on Connecticut law and how the Connecticut state constitution has been interpreted by our Connecticut Supreme Court, we are going to realize that employers have to engage in a balancing test and have to be able to articulate interests of theirs that are being impacted by the speech. And if there is little to no impact on the business, the employer may not be successful in quelling that speech. So this is a very recent decision, was just handed out earlier this year, and I think really speaks to some of the issues that employers have to keep in mind before they discipline employees for speech. Now let's take a look a little more carefully on sort of the history of how the Supreme Court has looked at speech in the workplace. There are three very important decisions that have come down from the U.S. Supreme Court, and they play very significantly into how the Connecticut Supreme Court has interpreted its statute, which we're going to talk about. Pickering was the first time the Supreme Court really looked at speech by an employee in the workplace. It was a decision that was rendered in the late 60s. Mr. Pickering was a school teacher. He had written a letter that was critical of the school board regarding how they were going to raise revenue for the school district. The school district did not appreciate his letter and dismissed him. The Supreme Court ultimately held that his dismissal was unlawful, and issued what is referred to still today as the Pickering test. And this is a test that the Connecticut Supreme Court has adopted in a very slightly modified form for analysis of speech under the Connecticut Supreme Court. But the Pickering test basically balances the interest that a public employee has as a citizen in commenting about matters of public concern against the interest of government as an employer in promoting the efficient delivery of their services. So basically, under the Pickering test, each case is going to be looked at individually, and there's going to be this balancing, and whoever has the greater interest will prevail. So if government is not protecting a very significant interest in being efficient, but the employee is speaking out on a matter of public concern, they're probably not going to be allowed to be disciplined for their speech. If the matter that they're speaking out isn't really a matter of public concern or a pretty nominal matter of public concern, but the speech is disruptive to the employer, to the government as an employer, or is somehow interfering with the government's ability to perform its services as an employer, then the government will be able to issue discipline. In this particular case, the court found that the letter, which concerned a proposed tax increase, was certainly a matter of public concern, and that the letter did not in any way impede Mr. Pickering's ability to perform his teaching duties. So there was no impact on the government in performing its duties, and thus found in favor of Mr. Pickering. Come, nearly 20 years later, or 15 years later, the next case that the Supreme Court took up was Connick versus Myers. And here again, the Supreme Court looked at an issue where a public employee was disciplined for speech. And in this particular case, Ms. Myers was an assistant DA. She had just learned that she was going to be reassigned to a different courthouse, and she was not happy about that. So she sent around a questionnaire to her coworkers, had a variety of questions. Do you like your workplace, and just a variety of general questions about the workplace. One of the questions, though, dealt with whether employees in the different courthouses felt pressured to work on public campaigns. And so Ms. Myers was fired after her questionnaire came to the attention of her supervisors, and ultimately her speech was not found to be protected. One, the court did weigh pretty heavily or focus on the fact that most of the questions, except for one, were not for a matter of public concern, and really was her reaction to something that happened to her in her own workplace, just in terms of her own work schedule, not of any matter of public concern. We come to a very controversial decision, Garcetti, and this decision is still talked about today. It's the Supreme Court's most recent commentary on speech by a public employee, and here the individual involved was a deputy district attorney, and he wrote a memorandum to his supervisors about why he felt a particular case that the office was handling should be dismissed. He felt that the subpoena or arrest warrant that was originally issued had some flaws and did not feel that the case should go forward. He was subsequently subjected to some adverse employment actions, such as reassignment, being transferred, and being passed over from a promotion. He brought a lawsuit challenging those actions. And here, the Supreme Court majority, and it was a 5-4 decision, they did come out with what they considered a bright line test. And this certainly is the law today under the federal Constitution. that when a government employee speaks in the capacity of their job, they are not speaking, in the opinion of the court, as a private citizen, and therefore the speech isn't protected. So the bright line that was issued is courts just need to determine whether the speech was in the capacity of their particular job or as a private citizen. If it's in the capacity of their job or relates to their job duties, then it is not going to be protected. In those cases, would be subject to early dismissal. Now, we come over to Connecticut, and there's a few states like Connecticut that have similar statutes, such as the one we're going to talk about, 3151Q, but they're few and far between. In our particular case, we have a statute that applies to all employers, both public and private, without any qualification on the size of the employer. And this statute protects employees from discipline or discharge if they are disciplined or discharged because of any exercise of their rights under either the First Amendment of the United States Constitution or Sections 3, 4, or 14 of the state constitution. Many folks forget that we do have a state constitution, and on some occasions, our Supreme Court has recognized that our Constitution gives broader rights to our state citizens than the federal Constitution does. Now, Section 3 of the Connecticut Constitution deals with religious liberty. Section 14 deals with the right to assemble. Section 4 is the section of the state constitution that deals with speech rights. And in particular, the Section 4 provides that every citizen may freely speak, write, or publish his sentiments on all subjects. Based on the text of the statute, our Supreme Court has, or on that constitutional provision, our Supreme Court has found that our state constitution provides broader rights than the First Amendment of the U.S. Constitution. And an employer who violates this statute, meaning they discipline or discharge someone based on the exercising of their rights under the state or federal constitution in terms of expression, can be liable for damages, including punitive damages and reasonable attorney's fees, in addition to any back pay or an order for reinstatement. So what exactly, or how exactly has that statute been interpreted? Well, the first case, which came out in 1999 that really looked at this statute, dealt with an employee at United Technologies. And in this particular case, United Technologies was gearing up to respond to some sort of proposal to do business for the government. They were going to have some government officials walking through their offices. And in preparation of that, they distributed to employees little desk flags for each of the employees to put out on their desks. Well, Mr. Lotto refused to do so. He felt that was an infringement of his constitutional rights. He was initially suspended and then he was discharged. The Supreme Court took the occasion. Oops, hold on a second. Okay, for some reason the slide's not advancing, but the court took the occasion to look at this statute and held that, yes, a private employer can raise a claim under this statute, but there are certain limitations. And here, what the court focused on was that the plaintiff had not made an allegation that he was directed to somehow manifest some allegiance of patriotism. Really, what they said was the employer, because they own the premises, can sort of basically dictate how the premises are decorated. And the flag, being asked to be placed on the desk was no more than a decision about how the workplace was going to look, and was not any mandate on the employees to compel some sort of allegiance or compliance to a certain ideology. And so in this particular case, although Mr. Lotto did not prevail, it's an important case for the idea that, yes, this statute does have import in the private workplace. Now, the next very important decision with regard to the Connecticut statute came a few years ago in the case of Trusz versus UBS Realty Investors. In this particular case, the Supreme Court was asked to opine about how the Garcetti opinion from the U.S. Supreme Court impacted analysis of a claim under 3151Q. You might remember 3151Q protects free speech rights under the First Amendment, but also protects rights under the Connecticut Constitution. So Garcetti now has established the rule about how speech in the workplace will be examined for First Amendment considerations, meaning if the speech relates to the employee's job, then that is not going to be recognized as protected speech. But the question put to the Connecticut Supreme Court was, does that same analysis hold true for the Connecticut Constitution? And they held that it did not. What they held was that they adopted the Pickering balancing test and basically said that speech that may not be substantially or materially interfering with an employee's job or their working relationship that does address a matter of public concern is going to be protected. In this, just to go back, so in the Trusz case, what Mr. Trusz was raising issues about was how certain auditing principles and certain fees were being calculated. He felt there were some errors. And the company brought in an auditor and affirmed his belief that, yes, there was errors being made, but the auditor felt they were not material errors that required either some reimbursement of fees or some restatement of financial statements. He continued to press the issue and ultimately lost his job over it. And then he brought a lawsuit challenging it. And so the court definitely recognized that there was a matter of public concern and that the court, it got remanded back to for a trial to examine whether the company had some substantial interest that outweighed Mr. Trusz's speech rights. So what should an employer do when they're faced with one of these situations? And I think it's almost inevitable that folks are going to find themselves faced with a situation either in the form of some social media posting or possibly direct speech right in the workplace. First, you really want to look at the substance of the speech. Certainly, is the person engaging in any illegal activity? For example, is the speech one that might constitute unlawful harassment, either based on someone's gender, someone's religion, or some other protected classification, such that the employer has an obligation to take action to eliminate that harassment? Secondly, does the speech indicate that the employee is not qualified for the position, or does the speech somehow truly impact the operation of the employer? I think, where employers have to proceed with caution is in terms of whether they speculate that the speech might have impact on their operation, or they find that the speech is simply distasteful. That is where employees really need to proceed with caution. For example, there's been cases that employees comment on social media about not liking the work. There was a case not too long ago where an employee was employed at a daycare center, and the employee commented on social media how she really hated working with children. So in that particular case, the employer was affirmed in the dismissal because really that speech wasn't about a matter of public concern, but was rather an indication of whether the individual really should be working in that particular job. So before we turn to questions, I think what you want to do in any of these cases is make sure you look at the speech carefully and in as objective light as possible, and that you not get caught up in any emotion that might follow from reading or hearing what the employee is saying. Hopefully that will allow the employer to really focus on what is the objective concern they have about the speech that the employee is engaging in. That will allow you to be in the best position to prevail in the Pickering test if a claim is brought under 3151Q or under under the Connecticut Constitution, or if you are not under the Connecticut statute, you want to focus on whether that speech relates to the employee's job or not. Because if it only relates to the job and you're only under federal law, then under Garcetti we know that that is not protected speech. Okay, with that, we're going to see if there are any questions. Give us just a moment. Okay. Okay, we haven't gotten any questions yet. Folks are saying that this was good information. I would say, another just parting thought regarding this topic is when you get into a situation where you feel like an employee is engaging in speech that you do not appreciate and that raises some concerns for you, that really is a good time to reach out to whoever your legal counsel is, just so that you could walk through what your concerns are. Certainly if you have copies of the speech or can get copies of the speech, do so it's very clear what the speech is that is at issue. In this area, it's very important what the words are being used. If the speech that was raised before the Second Circuit did not address an election campaign and did not comment on work conditions, but was simply a rant, a profanity-based rant, chances are it would not have been protected. So with that, we do have a question. What if the speech pertains to matters of public concern, but could also violate HIPAA or some other law? It's a great question. So this is where you would then, under Connecticut law, get into that Pickering balancing test, which before Garcetti was also true under federal law. So what you would do is, you never get in the door, by the way, as a threshold matter, even under Connecticut law. If the speech does not relate to any issues of public concern, then 3151Q is never triggered. It has to, at a minimum, raise matters of public concern. But that's a pretty broad threshold, meaning, the honesty of an employer, how they treat their employees. Like you could imagine, most issues are probably going to at least cross the threshold as an initial matter. Assuming it does raise some matter of public concern, then the question is, what is the employer's interest in not allowing that speech? And so this particular question raises that maybe the speech constitutes a violation of HIPAA or some other statute. And the example I gave a few minutes ago was that the speech constitutes unlawful harassment. And so in that particular case, I think the employer has a good chance of having a legitimate basis for issuing discipline. But what you'd want to do is make sure that the speech has a solid foundation for being considered a violation of HIPAA or whatever the other law is that you're thinking about. Again, the situations I've been involved with, there's been about a knee-jerk or an emotional reaction to the speech. I've had clients tell me that the speech is a problem, and they'll give me a reason. And when we look at the reason a little more closely, it's not quite as clear as the client first believed. So, definitely taking the time to really examine the speech and determine whether it's violative or not is important. And if it is violative, I think you're going to prevail in your ability to discharge. Next question. Do social media posts that are deemed inappropriate or harassing need to be addressed directly towards someone in a protected class for them to be disciplined? Well, the question is, is it harassment? Our law does protect many classifications. So if it's hostile or harassing because of someone's gender, gender identity, sexual orientation, color, national origin, those all could be potentially unlawful because they could constitute a hostile workplace or create a hostile workplace. If it's hostility towards someone's political affiliation is not protected under Connecticut law or under federal law as a protected class, so that may not be quite as clear of an answer. And that's where you want to look at, what is it, what's the problem with the speech? Even if it's not per se unlawful, but the speech is creating such consternation in the workplace or targeting an individual and really affecting the workplace, those are all things that potentially could play into the employer's interest in shutting down that kind of speech. And again, that's where I think employers have to walk a little carefully about speculating about the harm that the speech could have versus actually, experiencing that harm. So, for example, if an employee who was the target of the speech came to you and complained about the speech, and maybe the speech was part of a larger issue that employee had with the speaker, then I think you might have a case to proceed to either discipline or at least address the speech with the employee who's conducting the speech. But you would want to, I think you're better off at least having that feedback from the employee. Some of these cases, employers feel that, the speech is going to be disruptive, and yet the employees involved, have thick skin and don't think much of it, or no customers actually pay attention to it. And so that's where then the employer, can get into some trouble in terms of their burden to prove what their interest is in shutting down the speech. Next question. Do you recommend that employers develop a social media policy to advise employees accordingly, although it seems like we are very limited on holding them accountable? I do think there's some value in having social media policies. You definitely need to work with your legal counsel in drafting them. In large part, the National Labor Relations Board has been very critical of social media policies that that the board believes infringes or may infringe upon an employee's exercise of their Section 7 rights. So policies that are very broad, that speak to speech that would otherwise put an employer in an unfavorable light, have found to be too broad and unlawful. So again, I think if you have a narrowly drafted social media policy that really articulates what the concerns are, not having any hostile workplace, not having any harassment, and maybe any other concerns unique to your situation, that could serve you well when you do want to take action for, again, someone who has violated that policy. But again, those policies, I think, are better off when they are narrowly tailored, not unduly broad, because they will be challenged by the NLRA or NLRB, or any plaintiff's lawyer who then wants to get around them. Okay, it looks like we've answered all the questions. We, again, really appreciate you tuning in. We do these webinars on a monthly basis, and we encourage you, if there's any topic that you would like us to address, we'd love to hear from you. We've, in the past, gotten suggestions from participants about what they want to hear, and those are usually topics that other people want to hear. So please pass them along, and we appreciate you tuning in, and have a great weekend. Thank you.